So try to imagine this. You're the judge in court, and you're being presented by the following. We have a case in which there was a fight between two rivalry groups. There's one victim, down on the ground, dead, suffered severe head trauma. So now we're in court, and there's a prosecution. Prosecution comes up to the stand and tells you that there is DNA from the victim on the shoe of the suspect. So, therefore, the suspect must be the one kicking the victim in the head. On the other side, we have the defense. And the defense, of course, states the exact opposite in behalf of their client's best interest. They don't know how that DNA got to be on his shoe, but at least he did not kick the victim. So who do you believe? That's a hard question to answer when you don't have all the information, isn't it? So let's zoom out for a bit, and I'm going to try and tell you which information to look for before we can make a decision. Which topics we should address as forensic investigators and which we should address in court before we take decisions to put people away for a long time. Yep. So we start with this. Normally, we work from cause to effect. If I would drop a glass on the ground, there would be shadows on the ground, and you would tell me to pick them up. Now we come into the same room, and we work back from effect to cause. So there's glass on the ground. We don't know where the glass came from. We look around, try to figure out where the glass came from. But there's different causes that might lead back to this effect. And this is nothing new. Trying to deduce that effect is very hard. And as you've just been told as well, that there was already someone in the 19th century, an author, that figured out that we are all mesmerized by the fact of deduction and finding out the truth behind what really happened. But we still deal with that today. We deal with that today every day in court. But now we have to deal with legal professionals interpreting the objective forensic evidence. But as I just told you, they all have their own agenda. The prosecution's office thinks that the subject or the suspect is indeed the one kicking the victim, whereas the defense argues that he did not commit that crime. So we're going to see if we can put together by bits and pieces what the most probable cause is to the effect that we have. Yeah? Ian Abbott told us that if we are doing forensics, we always have to talk about the probability of evidence given a certain proposition. And this is already very hard when you talk to law people. I'll give you the example here stated. We have the evidence. We have an animal with 4 legs. And our proposition is that the animal is a cow. So if we do it correctly, you would state that the probability that an animal has 4 legs, if it is a cow, that would be very true. However, if you turn that around and you talk about the probability that an animal is a cow if it has 4 legs, it's not that probable anymore. So let's get back to the case. We have these shoes, and the evidence is that there's DNA from the victim on the shoe of the suspect. The proposition stated by the public prosecutor is that the suspect kicked the victim in the head. Yeah? So here we go. Probability of the evidence given a certain proposition. The probability of the DNA from the victim on the shoe getting there by the suspect kicking him in the face. That's pretty probable. If you kick somebody in the face, you're bound to have DNA on your shoe. Yeah? If you turn it around, however, and you go back to the probability of the suspect kicking the victim in the face when there's DNA of the victim on his shoe, there might be a different explanation for that DNA to be there. Okay? You with me so far? Good. How probable are we that we don't have a cow with 5 legs? This could also be AI. We've discussed that as well. How probably are we then? The thing is that if we're talking about probability, it's hard to actually state how certain we are. or how much evidential value we add to the picture. So in the 18 years that I've been doing this, I've seen many attempts to try to describe how certain somebody is about their research. And they describe it in different ways. But all the statements that are here on this sheet actually mean the exact same thing. That's puzzling, isn't it? So that means it's depending on which expert you have in front of you and which language he talks to convince somebody else of certain facts. So you can imagine that there's a judge who just wants a percentage of certainty, or at least a number. So, all the great minds in forensics bundled together, and we now came up with a system to have evidential value by terms of probability. But if I would state to you that the evidence is equally probable under both my hypotheses, that's one statement. Or the other statement is that the evidence is 2 times as probable under one hypothesis than under the other. Does that give you the same feeling? Doesn't do that to me. However, if you look at the way that we have to present our evidence now, it is the exact same thing. I'll show you the rest of this graph as well, and that seems hard to understand until you recognize that all of these numbers have been derived by frequency calculations on how many times a certain part of DNA is found in a DNA database. And then you can make a calculation. But it also means that all of the other suspects, all of the other topics that we talk about in forensics, they cannot use this numerical evidential value, because there is no way to determine how many times a certain letter is written in a certain way. We don't even know how many times a certain part of a fingerprint is present in a reference group. So we can't use these numbers. And then the expert has to state one of the verbal terms. So one of the questions I ask a lot is, how did you get to this verbal term? You know what the answer is? It's based on our expertise and the experience of the expert. All right? Back to the case again. In this case, it was stated that it was extremely more possible that the DNA of the victim was present on the shoe of the suspect. Neither of the parties discussed that. So, we now have an answer to our source level question, whose is it? The DNA is indeed the DNA from the victim. But we're not halfway there yet. The next question would be, how did it get there? How did that DNA end up on that shoe? And you can imagine that if I have a primary transfer because I am kicking somebody in the face, I would get a lot of DNA on my shoe. However, if there would be a secondary transfer by somebody else kicking the victim and then touching the shoe of the suspect, that there would be less DNA on the shoe. I can go even further. He didn't kick the victim, he hit the victim in the head with his fist, then took off his shoes, placed the shoes in the same cabinet as the shoes of the suspect, and the shoes touched one another. So you can imagine that there is less and less DNA on the shoe. The thing is with this DNA nowadays is that there's DNA everywhere. If I rub my hands and I go, how does that feel? You all have my DNA on you now. So if something happens here, I have something to explain. Because you have my DNA, but it's just a little bit of DNA. So, if I go back to the activity level questions and I want to know how much DNA there is, I have to make certain I'm not dealing with a primary transfer or a secondary transfer or maybe even a tertiary transfer. There needs to be a logical explanation for DNA to end up somewhere. The thing is, however, if we ask a party in a law case to come up with an alternative scenario for DNA to be present, you have to think back to that effect having different causes. So we try to ask for someone to make a choice in one of these causes, because that's something that we can investigate. Yeah? All right. If we look at the DNA on the shoe of this victim in this case, we will see that in this DNA, after asking these questions, there was 3 donors in this trace. One of the donors was actually the victim's DNA. But there's 2 other DNA donors in there as well. How did they get there? We don't know. We have to look for alternative scenarios. The DNA concentration of this trace in the shoe was actually very little. It's 0.006 nanograms per microliter. And why do I state it? Because all of our traces below 0.0002 nanograms per microliter are being discarded. I have to say 0.002 nanograms per microliter are being discarded. So you can see that how it's very little DNA, and there's actually 3 donors in there as well. Also, if you look at it, there was no blood detected on the shoe. Would that be a trace that you would expect after somebody being in a fight, actually dying from severe head trauma, to not have any blood on his face? And then if you touch that with your shoe, there would be no blood on the shoe as well? And also, to add up to that, the suspect was right-handed. And why am I telling you this? Because I already took the liberty of drawing in the trace on the shoes that have been in this image already. And I'm going to point it out with the arrow. So that's where the DNA was. Can you imagine that if you're in court and you're being presented by the evidence that there is DNA from the victim on the suspect's shoe, so the suspect must be the one kicking the victim, that's a prosecutor's fallacy. In this case, if the defense wouldn't have asked any questions, that would be where the investigative answers would have ended. So there would be no activity level questions. In this case, because we were asking the activity level questions, the Court of Appeal eventually had to say, we don't see this as a trace that is linked to the committing that crime that we are describing, and there was no other evidence. So eventually, the suspect was acquitted. It saved about 7 years of being in court or being in jail. Yeah? One of the main things that I started about is the equality of arms. It was written on my first slide, Criminalistics and Equality of Arms. If we don't ask the questions, we don't get the information. But the information's there. It's just not shared in the case file. So all this information, DNA profiles, which have the alleles in there, on the basis of which we can do the evidential value calculations, it's not shared in the case file. The DNA peak profiles, from which we can get amounts of DNA from different donors in the trace, is not shared in the case file. And also DNA concentrations are not shared in the case file. So how can we talk about equality of arms when we ask either of the parties to come up with alternative scenarios? So, forensic science isn't always about solving crimes. It's about searching for the truth that is often fragmented and hidden, and therefore it's not what we see in the evidence that is presented in court. It's zooming out and looking back, asking ourselves, did we ask all the questions there are to ask about the evidence? Thank you.